One of the things that we haven't talked about yet is that before your trial even starts, you're going to want to make motions. They're usually called motions in limine right before the literal trial starts, like a few minutes before. Um, these motions to exclude evidence, so they're not even brought up in trial, right? I thought about this when we were talking yesterday about how to introduce evidence, right? So just to refresh your recollection, um, to introduce evidence, you say, I have in my hand what's been marked as Exhibit X, showing to opposing counsel. May I approach the witness? I'm handing you what's been marked as Exhibit X. Do you recognize this? How do you recognize this? What is this? Move Exhibit X into evidence. Now you can ask questions, right? So, but sometimes you don't want the other side to bring the evidence in at all, or even to ask questions about it. So, for instance, you know, let's say your person um, is a murderer, but they committed a murder last year, right? Um, you don't want the jury to hear that they've already committed a murder because that's pretty prejudicial, right? So you will make a motion just before the trial starts. Honestly, in the real world, you would make this long before, but for our purposes, you'll make it right before the trial starts to say, Your Honor, under 403, Rules of Evidence 403, we'd like to exclude any mention of the prior murder because it would be more prejudicial than probative. It would inflame the passions of the jury to think that because he had murdered before, he must be guilty of this murder, right? Um, so you make that motion in advance, right? And a lot of the things that happen in trial, we talked about how they're not surprises, right? Both sides know what evidence is going to happen in the trial. They're kind of trying to spin it their side or the other. But really, what makes or breaks a trial is what evidence is allowed to get in, right? The jury only hears what is allowed to be brought in because it's been excluded because it's, in some way protected or it was gathered in a bad way, like under the exclusionary rule, the fruit of the poisonous tree, where the police did real bad wrong and busted down your door without any sort of warrant, or there wasn't a hot pursuit exception. They just came into your house and took all your stuff and said, "See, he did crimes." Right, but we don't want to reward the police for violating our Fourth Amendment rights. So we're not going to let them use that evidence against us because they violated our rights. Um, a few days ago, you guys know the Luigi Mangione case, right? The guy who shot a CEO of, was it United Healthcare? Um, so he was found in a McDonald's, and he was questioned, and his backpack was searched. And in the backpack they found I don't know, like a silencer. They found a notebook. They found a few things, like maybe a gun. I can't remember. They found evidence against him to suggest that he was the one who killed this CEO. And the defense said, wait a minute, you didn't give him his Miranda rights. You didn't arrest him. You were just questioning some random person in a McDonald's and then rooted through his backpack and found all this evidence against him and then decided to arrest him, right? And so this wasn't a search incident to arrest, which is one of our exceptions, because he wasn't arrested. It wasn't a Terry stop because the backpack was sitting in the bench behind him while he was talking. So you could pat his, pockets down and he had no weapons. It wouldn't even be kind of the wingspan exception, right? When you have an arrest and you have to search things around him for a weapon, because he wasn't arrested. So the defense tried to keep all this evidence out. The judge finally ruled a few days ago and said, yeah, no, it all comes in, because they bought the prosecution's argument that they would have arrested Mangione eventually, right? As a result of the questioning and his description matched and whatever else, right? And so once he was arrested, they would have done a complete search of the backpack. They would have done an inventory of all the things that were in the backpack once he's arrested. They would have found the stuff anyway. So this is the inevitable discovery doctrine. And so this kind of bypasses the exclusionary rule, the fruit of the poisonous tree rule, that says if you violate our rights, you don't get to, profit from that, right? But the court said, yeah, but even if you hadn't violated his rights, you would have eventually arrested him anyway. So we'll allow this evidence in. Cool. So anyway, so keep that in mind as your trials come up. Are there things that you want to try to keep out before the trial even happens? Um, and by the way, if you've excluded something, or successfully excluded something, really listen carefully because sometimes people get so stuck in their scripts or in their, the text of their closing argument, and they don't remember to not mention it. And that would be grounds for a mistrial if they started talking in closing argument about something that had been excluded. You'd argued successfully the prior murder should be kept out, and they talk about it in closing argument. Now the jury has heard this. There's no, unringing the bell. That could be grounds for a mistrial. They have to do the whole trial all over again, right? Okay. So this week you're doing cross-examinations. They are really fun to do. So whoever is assigned in your group to do a cross-examination, you're going to love it. You are telling the story. So you don't want the witness to talk at all except for saying yes and no. So use very leading questions. Make statements basically. This happened, then this happened, confirm. This happened, confirm. This happened, confirm. You want to control your witness. They're going to try to be evasive. They're going to try to give you explanations for things, right? Just repeat the question calmly. Don't argue with them because you are in control. Okay? Again, just like with direct examination, don't do compound questions. It's one fact per question. But I think even want to baby step it out further in a cross examination because you don't want to give them a chance to have to argue out of it or be able to argue out of it, right? Don't have any ambiguity in your questions, So it's like your name is Gavin, yes, and Gavin starts with a G, yes. So you've heard the letter G before, yes, right? You can't argue with these facts. So they're such small little individual facts, but they'll build, right? Um, don't ask the one question too many. Don't try to pull together all your facts, right? Once you have on the record them saying yes, 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 you can pull it together as to what that means in your closing argument, right? Never ask a why question. This is a trick that I had on the quiz, right? For direct examinations, your questions start with who, what, when, where, why, how, right? Um, for cross-examination, you know the answers. You don't want them to explain anything. You're trying to get them to confirm your version of the story, right? Um, and then, of course, if they say the wrong thing, instantly jump on the impeachment. You might not have to go through the entire impeachment litany that I talked about in the last video because they might instantly fold, right? As soon as you say, you remember giving your deposition in this matter, they might say, yeah, oh, the light was red. You're right. Okay, move on. All you need to do is get them to say the other thing. You can definitely talk about that in your closing argument, about how they, on the stand, flip-flopped, right? And how they're not a reliable witness or whatever. Um, keep very calm but be very firm, right? Don't argue with them. Don't lose your temper. You want to look very professional and in control. You can be a little angry at them if they're the ones who did something bad, but you are in control, right? Um, right. So don't ask one question too many. Don't argue with the witness. Don't allow them to explain things, right? Keep the witness restricted to very simple, direct answers. It might not be yes, no, it might be green, red, or whatever. But as soon as they start talking for a long time, do your best to stop them, right? Um, okay. I'll stop there for today.